Bella, am I live?
Yes, you're live.
Okay. Let's go ahead and get started. We're here on a status conference in the Hume case. Ms. Shigaris, why don't you give us the cause number and the full name of the case? And then you said there were 4 issues that we need to discuss today and try to get resolved.
Yes, Your Honor. Leslie Shigaris here on behalf of the FSG parties. This is DC 20-08643, Mark Holm versus 5-Star Global et al. And with me on behalf of the FSG parties are Tyler Bexley and Jessica Lopez. The first issue, Your Honor.
Let the other side make their announcements.
Julie Pettit-Greason on behalf of the home party.
Ben Reamer on behalf of the Null parties.
Okay,
This is Sarah Krajewski on behalf of defendant Southfield Mezzanine.
Oh, I'm sorry. I keep forgetting you're a separate party. We should be, I apologize about that. Okay, let's get started, Ms. Shigaris.
Thank you, Your Honor. The first issue relates to requesting a briefing schedule from Your Honor. The plaintiffs about 2 weeks ago raised an alleged conflict on behalf of the FSG's retained expert, Gary Durham. And Mr. Bexley, my colleague, is going to handle that issue, Your Honor.
Okay.
Thank you, Your Honor. So we filed an affidavit or a declaration of Gary Durham acting as an expert in this case at the beginning of January 4th. And a couple of days later, Ms. Greason raised an objection or an issue with a potential conflict because, as I understand it, Mr. Holm, the plaintiff, had some discussions a few years ago with Mr. Durham about serving as a retained expert in an unrelated piece of litigation. And the plaintiffs alleged he was shown some financials that may also have included some information about parties in this case. And although Mr. Durham was not ultimately retained in that case, Ms. Greason and her client have alleged that there is some potential conflict of interest that would require disqualification or potentially require disqualification of Mr. Durham. Shortly after that, we reviewed the case law and discussed with Mr. Durham the issue, and we came to the conclusion that there is no basis for disqualification and communicated that to Ms. Greason. She still believes, as I understand it, that there is a conflict. And so we requested that rather than drag this along and have Mr. Durham do a bunch of work only for there to be a claim that he should not serve as an expert in this case, we tee this up for Your Honor to decide early on, right away, with a briefing schedule so that we can all move forward knowing whether Mr. Durham can or cannot continue to serve as an expert. Ms. Greason's position was, well, I'm not 100% certain why there's an objection or if there's an objection to a briefing schedule, but the only response we got was adding Mr. Durham to an email chain and saying, this is for Gary to decide, and if he proceeds, he does so at his own peril. And that statement caused concern for Mr. Durham, who has said he does not want to continue undertaking work until this issue has been briefed and decided by the court. So we are requesting that the court set a briefing schedule and a fairly quick briefing schedule because we are trying to mediate this case on March 9th, and his analysis will be useful, in fact, necessary for our clients to see some analysis from him prior to the mediation. And then we have depositions beginning. I don't think they're actually scheduled yet, but contemplated for starting in the next few weeks, where, again, we would want to be able to consult with Mr. Durham and have some clarity from the court on the claim that is being raised by Ms. Greason here.
Ms. Pettit-Greason.
Thank you, Your Honor. So when we first realized that they were considering Mr. Durham for purposes of this case, it immediately became a huge concern of ours. So just by way of background, Mr. Holm's entity is 5-Star, which was formerly 5-Star Institute. 5-Star Institute is the largest owner of a company called Fan Expo, which was in extensive litigation with the NFL a couple of years ago. As part of that litigation, Mr. Durham was involved in, I would say, very, very detailed discussions with myself, Mr. Holm, and Michael Hurst. And as part of those discussions and our potential engagement with Mr. Durham at the time, he met with Mr. Holm on multiple occasions and received highly sensitive information regarding 5-Star, which is now the subject of this litigation. As soon as we realized that they were for whatever reason, talking to Mr. Durham about testifying against Mr. Holmes' company after he received his confidential information. We brought it to their attention. And I sent an email to Mr. Durham, copied counsel, and said, hey, Gary Durham, I need to talk to you. This is highly concerning. Mr. Durham has since spoken with myself and Michael Hurst. And Mr. Hurst's memory is the same as my memory, is the same as Mr. Holmes' memory, which would be that Mr. Durham has a very, very large conflict if he's going to now testify against Mr. Holmes. And those conversations with Mr. Durham, he notified us that before he was actually retained for this case, he informed opposing counsel that he had had these meetings with Mr. Holmes. Now, it doesn't seem that he remembers the extent of the information that he received, but he notified them that he did indeed have these meetings with Mr. Holmes, and he told Mr. Hurst and myself that he was assured by opposing counsel that there was no conflict. Now, I find it hard to believe that opposing counsel could inform Mr. Durham that he has no conflict and assure him that he has no conflict when they weren't even aware of what information he received as part of those meetings. In my conversation and Mr. Hurst's conversation with Mr. Durham, he indicated, look, I'm busy. I don't need the business that bad. This case isn't that big of a deal to me. It's not the end of the world. I don't really want to get involved in this, that type of thing. So based on that, it was our belief that he probably wasn't going to move forward with this case at all. So we haven't filed a motion because, as I mentioned, it seemed as if Mr. Durham really wasn't going to be involved in this case. And since that time, the only communication I've had with Mr. Durham, I haven't returned his most recent calls. My understanding is Mr. Hurst hasn't either. The only communication I've had with him was an email in which I copied counsel. So I haven't had any other written communication with Mr. Durham. So I don't know. I'm not even sure this is going to be an issue. I mean, it's our position that there is absolutely 100% a huge conflict if Mr. Durham decides to move forward, which is why we said, look, if you're going to move forward, Mr. Durham, you're doing so at your own peril, because clearly we have remedies if an expert chooses to do that when he's received confidential information from a party that he's now going to go against. So if he's going to move forward, then certainly if my client chooses to file a motion, then that will be an issue at that time. We haven't filed one yet because, like I said, it's our understanding that he wasn't necessarily going to move forward.
Has he officially been designated as an expert?
Well, we have not yet reached the disclosure point in terms of designations on request for disclosure. We did serve an affidavit in which he communicated that he has been retained to serve as an expert in this case and does intend to serve as an expert in this case. And to be clear, we are still intending to proffer him as an expert. And so this is an issue that will need to be addressed by the court. I can address some of the reasons why we don't think there's a conflict, but I'm not sure that's a good use of time since we're not there yet.
I kind of let you guys talk a little bit about it, so I had a little bit of flavor, but I'm not making any decisions today on that. So I know that attorneys like to fight. You don't want to let them get the last word in, but I'm not going to make a decision about this today. So I really just want to figure out, is a briefing schedule appropriate? Is it not appropriate? Should we, if there is, usually in most cases, as we all know, that you would have a, designation deadline, and then you'd have a deadline to move to strike experts. And that's how you normally handle this. I don't know that I've seen this exact scenario come up where an expert potentially has a conflict that would prevent them from testifying, and how that should be handled in a scheduling order. I assume that y'all have in the scheduling order in this case, is there a deadline to move to strike experts?
I'm not sure whether where you're acting under just a level 2 order or whether that's specific in there. I'd have to go back and look at the scheduling order unless someone else knows off the top of their head.
I believe we do have a separate deadline, but Your Honor, of course, that would come after Mr. Durham has done all the work in this case. And what we were trying to do was allow Your Honor the evidence that Ms. Pettit-Greason would put forward and our side would put forward. So that way, if Your Honor determines there is a conflict, then Mr. Durham hasn't done any work, and it hasn't, one, for his own protection, because I think he is worried based on the comments from Ms. Pettit-Greason that they're going to try to sue him or allege some wrongdoing. He, wants to know up front, is there a conflict under the law or not before he does any substantive work? And of course, for our client, if we paid him to do all this work and then he was ultimately stricken at the last minute, that would, wouldn't be a good situation to be in. But that's really why it's a little different, because they're alleging he should not be permitted to look at any records or do any work on the case. So we wanted to tee it up kind of, and it is a little bit in reverse, but just the conflict issue. And then if there were qualification issues or anything based on his substantive report, that would be handled during the normal term.
I mean, that makes sense. Ms. Greason, Ms. Pettit-Greason, what do you think?
Yeah, if Mr. Durham is still intending to move forward, which again, that's why we haven't run out and filed anything, because we got the feeling that he wasn't comfortable moving forward when he had the fact that he thought there wasn't a conflict was based on representations he received from opposing counsel. So if opposing counsel is saying that he is moving forward and that's his position, then I don't have a problem with the briefing schedule. But I'm not going to, I know experts take that pretty serious if someone files a motion to strike. So I'm not going to run out and file a motion to strike against someone if they're not going to move forward.
So what my thought is, so that he hasn't officially been designated. It sounds like he filed some kind of affidavit, but no official designation. What if we did, and you said the mediation is in March, is that right?
March 9th, yes, Your Honor.
You want to try to get this teed up before that deadline, is that correct? Or
I think to have a decent chance of settling the case and knowing what the numbers look like, we would really need to get some work from him in advance of that.
And Your Honor, just a complicating layer, we obviously, as you know, have insurance on the defense side. And so as you might be familiar, we have a lot of outside counsel guidelines that we have to adhere to in preparation for mediation, this being one of them, which is why it's also so important for the defense and the insurance covering some of the defense that Mr. Durham's conflict issue is resolved before he does any work and wastes the policy down even further from settlement perspective.
okay, that sounds reasonable to me. What kind of deadlines do you want, or what do you need? I'm very flexible on this, whatever you guys would like. It'll be a little difficult just because you'd have to be able to set a hearing with me. You want this decided, I guess, before the mediation. It's just, we're on a kind of a tight schedule, but I would almost say.
Yeah, I guess I hate to jump in. I'm a little bit confused if they're wanting, is he going to be reviewing all of this information in the interim, or is that going to be on hold pending a ruling? Because it just seems like it's going to be difficult to have a ruling and the ability to review everything prior to a month-ish from now when we're going to mediation.
Our position would be we're holding him from reviewing documents because we don't want him to run up and, again, as Ms. Lopez noted, waste dollars out of the policy that he's being paid if there's going to be a determination that he can't serve as an expert in this case.
And I think we also, and Ms. Pettit-Greason, you can correct us if we're wrong, we believe that you are taking the position that he is not permitted to see any financial information that you may produce to us in the next few weeks, subject to the motion to compel that we've addressed with the court a few weeks ago.
As much as I wish I had the authority to do that, I don't think I have the authority to tell Mr. Durham what he can or can't do. I just think I can take action if we think that he shouldn't be participating as an expert against someone from whom he's received confidential information. So I don't think I have the authority to do that. That would be my wish, but I can't control what you guys do, obviously.
Well,
So
we're
what if we did something like this, just from a logistics standpoint? This has to become, I agree with Ms. Pettit-Greason, this has to become kind of a live issue. And so to make this a live issue, you have to designate him. So I would suggest that you guys have to make a decision by maybe, to have any chance to get this done by Wednesday, you would need to either designate him or we're not going to be able to do this briefing schedule. So designate him by Wednesday. Ms. Pettit-Greason will have, let's say, a week maybe to file a motion. I know you're in the middle of trial, but a motion, maybe a week to file a motion to strike. So let's kind of work out the exact dates here. So Wednesday would be the 27th, January 27th. Durham designated or not designated? If he's designated, then you would have until February 3rd to file, plaintiff would have until February 3rd to file a motion to strike based on conflict. This is not going to be on any other ground. And then let's say February 10th would be the response date to the motion to quash or motion to strike. And then the hearing would be February 15th, maybe. It's awfully aggressive, I know, but what do y'all think? Is that too aggressive, or?
We can make that work from the defendant's perspective, Your Honor.
Ms. Pettigrew?
I think we can make that work.
And just to clarify, when we're talking about designation, this is just identifying him by name, not substantive opinion or anything like that at this point in the case.
You need to do a request for disclosure designation.
Okay.
So she knows what exactly he's offering an opinion on. So it doesn't mean you need to make a report, but you have to at least you need to at least comply with the rules on designation. And you don't need to do a report or anything like that.
Okay, thank you.
All right, so do you guys want to put together an agreed scheduling order, or briefing schedule, or however you want to do this? But we need to have some kind of order on this if the deadlines. And then on February 15th, Rhonda, go ahead and set a status conference on this case, let's say for 3 o'clock. And we'll include in the status conference, if this all gets teed up, include this motion to strike at that time slot. So February 15th at 3 o'clock. Rhonda, go ahead and add that to the schedule. All right, she got it. Okay, that's issue number 1. Let's do issue number 2.
Yes, Your Honor, we had our motion to compel against the home plaintiffs that Your Honor heard on the 15th. We submitted competing orders that agreed on everything other than the time frame for the plaintiffs to produce documents. It's already been 10 days since that hearing. We proposed that they produce documents 14 days from the date of your order, so that would really have given them 24 days from the date we had your oral rulings. The plaintiffs have requested 30 days from the date of your order, and our concern, as we've kind of already talked about, is we need time to get these documents, not only so we can move forward with depositions that everyone is trying to schedule in February and early March before the mediation, but we have to analyze them before any chance of a productive mediation.
So I am share screening this docket. So where are these orders that you're talking about? When were they filed?
I think the 9th.
Is that this one?
Yes. So the only question would be.
That was the one that we submitted before the hearing. We submitted a revised one after the hearing based on the rulings, Your Honor.
Yes.
All right, thank you. How about this one?
That looks right. If there's a blank, yes, that is the order that was presented by the defendants, where we've left a blank and the time frame for the plaintiffs to produce responsive documents.
And that's the only disagreement. It's just the time frame.
Yes.
Your Honor.
So what, Ms. Pettigrew, at this point, would 14 days work, or what are your thoughts?
I have indicated that we will certainly do our best, but I don't want to promise 14 days just because we don't actually know the full volume of the document. So obviously it's in everyone's best interest to get it done sooner rather than later, but I would ask for 30 days just so that we can do our best to make sure.
And I'm going to go ahead and just again, be a little bit of Solomon here and do 21 days from the date of the order. Okay, so that's the second issue, and I'll go ahead and sign that once we are done with this hearing, and I'll send that into the court clerk. What's the third issue?
As I mentioned, Your Honor, originally set for today was FSG's motion to compel documents from the null parties, Mr. Reamer's clients.
And you want to reschedule that?
Yes, we got a new date from the clerk, but it's not until February 15th. And so we had discussed with Mr. Reamer trying to set a short setting either on the 4th or the 5th of February. And I know your docket's very full, so whatever the court can accommodate.
You know, sometimes I feel like attorneys don't realize I do have right now about 1,500 other cases. So, but let me see what I can do.
And if you can't accommodate, we do understand, Your Honor. It's more just trying to get everything for this mediation to have a chance of success. And
let me see what I can do. Let's see. Oh, what is this? Oh, wait a minute. Never mind. I did that wrong. Okay.
And if Your Honor, and if it's okay with Ms. Shigaris, if it's any easier to do it earlier that following week. I mean, I realize the 15th is a ways out, but as opposed to next week, if we could
I don't look terrible on the 5th. It looks like we have let me just double check one thing. Yeah, okay. Yeah, February 5th would work. Rhonda, go ahead and move that hearing to 11 o'clock that day. 19287. Are y'all waiting for a Kimberly Quirk on this case? Is that y'all?
no, Your Honor.
Okay.
No, Your Honor.
So go ahead and set it. And it's the motion to compel Ms. Shigaris. When you call, can you call Rhonda and tell her exactly what the name of the,
Yes.
we've had so many motions to compel. I want to make sure we're setting the right one that day. So,
Yes.
Probably just so I can read it. And then you said, I think your fourth issue was involving the trial setting. Is that right?
Yes, Your Honor. But when we had our hearing on the scheduling order, we had agreed to November 2nd as the trial date. But as you will recall, that is a non-jury day.
Yes.
But you had said, well, we can set it that day and pick a jury, before and use that day for pretrial. But when we got the notices from the court, it had set us on a non-jury docket. So I had emailed Ms. Pinson just to make sure that the docket was, properly reflected. I think because of that, she moved us to November 16th because of the jury trial issue. The problem is I have an arbitration on the 16th. So we just agreed we raise it with you and see if it's okay.
Yeah, so Rhonda, that needs to be set on the jury docket for November 2nd. And hopefully we'll be trying cases by then. So just put that on this case on the jury docket. It looked like to me, I thought that it was on that date, but let me double check.
It was on the 2nd. It was just set on a non-jury instead of a jury. And
No, I just meant that I thought this case was set on November 2nd, but maybe it was and it got moved. Let me see. Let me just double check here. Okay. No, you're right. It's on November 16th. So yeah, Rhonda, go ahead and send a new notice out for November 2nd on the jury docket date.
Your Honor, the only thing I'd like to note on that is we obviously, I think I've done this every time we've talked about the trial date. We do disagree whether or not it should be a bench trial or not. So there will be forthcoming motion practice on that as well.
If you guys want to do this if it's going to be a bench trial, I'd like to try it as soon as possible because once we start jury trials, it's going to be very hard to do any non-juries because we're going to be just doing jury trials forever. So that's something else you guys might want to think about because I always put non-jury cases behind jury cases unless we have a non-jury week. And I guess we do have some non-jury weeks the second half of the year, so maybe we could figure that out. But something you guys might want to think about is if you want to move it up if it's going to be a non-jury, but it's up to y'all to work on.
From our perspective, both parties demanded juries, and that's our intent. But I agree, if Ms. Pettit-Greason is going to raise this issue, it behooves all the parties to know sooner than later if it's going to be on a jury trial or not. So
Sounds good, guys. Anything else we need to chat about?
that's it. Thank you so much for your time, Your Honor.
No problem. You guys be safe out there, okay?
Thank you.
Thank you, Your
Thank
Honor.
Thank you. Bye-bye.
Have a good day, Judge.
You too. Ms. Quirk, are you here for the motion for summary judgment?
Yes, Your Honor.
And is the other side going to show up?
If their motion and they set it for hearing, so I assume that they're going to show up.
Okay. All right. Give me a second. I need to run and go, run and go scan something.
Okay.
Ms. Quick, are you there? Quirk, I'm sorry, Ms. Quirk, I apologize. I don't
Yes,
see your
sir.
opposing counsel here.
Um,
Isn't this set for 3 o'clock?
It is, Your Honor. Yes.
Do you want to call them and find out what's going, it's their motion, right?
Yeah, it's their motion. Let me try to call him really quickly.
Okay.
Sorry, Your Honor, before I start the call, do you want me to have the mic on and put it on speaker so you can hear, or do you just want me to?
Yeah, why don't you do that? Just
Okay.
Thank you for calling Barnett and Garcia, PLLC.
oh no, you have to go to see how they have one of the
Law firm handles debt collections. We are debt collectors, and anything you say or provide will be used for that purpose. You've reached us outside of our normal office hours. Our hours are Monday through Friday, 9 a.m. to 5 p.m. If you know your party's extension number, you may dial it at any time. For a company directory, press 1, or you may dial 0 to leave us a message. Please enter 3 or more letters of the person's first name, then press the pound key. 4. Ian McCarthy. Press 1. To enter a new name, press the start. Please hold a moment.
Sorry, Your Honor, I had not had the pleasure of calling.
yeah,
Mr.
we've had to call
McCarthy?
them before. It's ridiculous. I feel bad for their
Ian McCarthy
suing.
does not answer. Start recording at the tone. When you are done, press the pound key or hang up.
Hi, Ian. This is Kimberly Quirk calling regarding the motion for summary judgment that was set for 3 p.m. today. If you can give me a call back, my cell is 214-493-6565.
Well,
Thank you.
tell him he's in the middle of a hearing.
The hearing's supposed to have started just 12 minutes ago, so please.
And the
log
judge is
in.
waiting.
The judge is waiting. So please call or log on. Thank you.
Rhonda, have we heard from him? Let's see what Rhonda says.
I'm going to try to send him an email as well.
Well, what do you want to do? Do you want to just cancel it or?
I honestly, I don't know, Your Honor. It was their motion. I thought our response was quite compelling, but I can't really argue it if he's not here.
No, I agree. I mean, I can deny the motion and then he can file a motion to reconsider. I don't know what his situation is? Does it, is he the only attorney listed on this case, or is
I see another two attorneys' names. I can try calling with them. I honestly, they've never reached out to me, and I haven't spoken with them, other than through email and e-service discovery, and it's all been with Ian. I can try calling a couple of these other numbers really quick if that's what, or
I'm just, you know, I'm flexible, whatever you want to do.
I mean, I'm ready, so if they can get on, then that would be great. But I guess I'll try calling one other one of these
Okay.
numbers, and maybe he'll answer the email in the meantime.
Thank you for calling Barnett Garcia, PLLC. We are glad you called. Please note that this law firm handles debt collections. We are debt collectors, and anything you say or provide will be used for that purpose. You've reached us outside of our normal office hours. Our hours are Monday through Friday, 9 a.m. to 5 p.m. Please enter 3 or more letters of the person's first name, then press the pound key. 4. Matt Garcia. Press 1. To enter a new name, press the star. Please hold a moment. Matt Garcia does not answer. Start recording it.
Yeah, I'm not sure what to do at this point. I think obviously my preference would be the method you suggested about denying the motion. He could ask for it to be reconsidered, but I'm biased in my favor, of course. So
I mean, if he has a good excuse for not being here, I'll probably just hear it kind of on the merits. But if he doesn't, or maybe he's withdrawn it because he thought your response was so strong, he just didn't tell any of us.
yeah, that would be really nice.
I mean, I think it was a decent claim on usury, so maybe he just decided he should have told you and told us. But have you already submitted an order on this to deny it?
I did submit one this morning to deny, but it has not yet been accepted, so I don't believe you'll be seeing it on your end.
Why don't you go ahead and email Rhonda, my court coordinator, the order, and I'll try to get it signed today.
All right. Thank you so much, Your Honor.
All right. Thank you, Ms. Quirk. You have a good day and be safe,
Yeah,
okay?
you do the same.
All right. Bye-bye.
Bye.
Let's see. Our next hearing is at, we have a very interesting hearing at 3:30. I'll go ahead and turn off